All right, buckle up, because this courtroom run is way heavier than it sounds at first. We've got a defendant facing manslaughter, another charge stacking up with prior convictions, and the judge making sure every guilty plea is freely and voluntarily entered, because one mistake here can blow up the whole case later. And watch closely. When there's no plea agreement, sentencing becomes a roll of the dice, especially with enhancements. The question is this going to end in mercy or a hammer drop at sentencing?
Do it on a different day. Yeah. Okay. You're Michelle Cormier?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Yes, ma'am.
Ms. Cormier, in clause number 25, DCCR 1446, let's see, are we going on with the prior or just the?
With the prior judge.
Okay. Let me, you're charged, hold on. You're charged with manslaughter from November 2nd of 2024. It's a second-degree felony. The indictment alleges you were previously convicted of burglary of a habitation, a second-degree felony, January 30th of 2013. And how do you plead to that charge? And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they've charged you with? And is that prior conviction true?
Yes, ma'am.
Sorry, it takes me a minute to get it pulled up. In cause number 25, DCCR 1447, you're charged with possession of a controlled substance, a state jail felony from October 30th of 2024. The indictment alleges you were previously convicted of possession of a controlled substance, a state jail felony, January 30th of 2013. In two different cases, or three different cases on that date. And what that means in that case is that would be enhanced to a third-degree felony. Do you understand?
Yes, ma'am.
And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And are those prior offenses true?
Yes, ma'am.
In each of those cases, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Radford?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And so there's no agreement, correct, in either of the cases. So I want to make sure you understand that you have an absolute right to have a jury come in and determine two things. The first is to determine if you're guilty or not. And then if they find you guilty in the case, you could leave your punishment up to that jury. If we go forward this way, you're leaving your punishment up to the court. And is that what you want to do?
Yes, ma'am.
State tenders number 1 in each case.
No objections.
It's admitted in each case. Is there any evidence that Ms. Cormier is not competent?
No, ma'am.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done, and then we'll come back for that hearing. Anything that you think is important for me to know, get that information to Mr. Radford, and he will present it to me on your behalf when we come back.
Judge, we're gonna have some letters that I will submit to the court to supplement the PSI, and I will copy Mr. Coleman on those support letters.
Okay, sounds good. And if you'll just try to get those to the court that week before
Yes, ma'am.
The hearing, that would be great.
Yes,
All right,
ma'am.
thank you. You can go
Thank
back
you.
with the bailiff.
I'll be-
Yes, sir.
This is Madam with the court's permission. This is basically a misdemeanor offense, but due to the nature of it, it's TDC.
Good morning. Are you Adrien Banks? And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Banks, in cause number 25 DCCR 1432, you're charged with a third-degree felony offense of harassment of a public servant in count 1 of that indictment, and that is from September 1st of 2025. And how do you plead to that charge?
Guilty now.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am, I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Banks is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of, in count 1, of harassment of a public servant, sentence you in accordance with your agreement. It was 2, right? To a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Are you Raymond Sweet?
Yes, ma'am.
And Mr. Sweet, in cause number 25, DCCR 1531, you're charged with a first-degree felony offense of burglary of a habitation with intent to commit another felony, and that's from August 22nd of 2025. Your indictment alleges you were previously convicted of burglary of a habitation May 28th of 1987, and also burglary of a vehicle on that same date. And then after those were final, you were convicted of robbery April 20th of 1988, and also burglary on that same date as well. And then after all of those were final, you were convicted of aggravated assault of a correctional officer June 8th of 1992. What that means is that if you go to trial and you're found guilty and those prior offenses are true, the range of punishment in your case would be between 25 years and up to 99 years or life. Do you understand? And I have a plea bargain rejection here on the tablet that you've signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 30-year term in prison. You have every right to reject that offer and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? I'll get that done. I do want to make sure, Mr. Smith, is there any reason to believe that there's any other evidence or that offer would change?
It's not going down.
So I want to make sure you understand that I will not accept that offer after today. If you change your mind and you want to enter a plea of guilty, then it would be to something different or open to the court. Also, so do you want to go forward with trial? Okay. Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint someone else today who could begin preparation for trial a little quicker. Is that okay with you? So, Mr. Rojas, you're released. We will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff. Yes, sir. Else? So, Mr. Rojas, you've been appointed to represent Mr. Sells. Is there any reason to believe that the person standing before me is not Mr. Sells?
No, Your Honor.
And so I'll take judicial notice of that, as well as the court's file, including a report. Mr. Sells was evaluated for competency to stand trial by Dr. Hamza. I have received that report dated November 14th of 2025. The finding is that Mr. Sells is not competent to stand trial at this time. Is there any other evidence with regard to competency?
No, Your Honor. Not from the state here.
Then at this time, based on that evaluation, I am going to find that Mr. Sells is not competent to stand trial. I'm going to order inpatient treatment at the appropriate facility for a period of not to exceed 120 days from the date he gets to that facility, and then we'll await a report from that facility. He can go back with the bailiff. We're gonna get you, we're gonna get you some help, and then you can come back and take care of your case, okay? Go back with the bailiff, okay? Right there, go back, go to the back, okay? Weapon from July 27th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
We've got, it's admitted. I know, back up.
Sorry.
Is there any evidence that Mr. Brousard is not competent?
No, Your Honor.
You need one?
I'm not. Thank you.
All right, Mr. Brousard, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Mr. Nichols, what is the state's position with regard to bond reduction based on the nature of that plea agreement?
Your Honor, he has a prior successfully completed probation for deadly conduct. The situation involves an in-home argument with his adult sister where he shoved her and brandished a machete. My concern would be if he was released, where would he be awaiting sentencing?
Mr. Brousard, when you are released, whether it's on a bond or when you get this probation, where will you be living?
4948 Lawndale.
And who lives there?
My mother.
Who else?
There's 2 other couples. There's Lindsay's daughter, my niece, and her boyfriend, and another couple.
Okay, where does Lindsay live?
Lindsay lives at the lake, Toledo Bend.
So you understand that you're not going to be able to have contact with Lindsay?
Yes, ma'am.
So if there's some family get together at the house where you're living, you're gonna have to leave if she comes
Judge,
over.
I do have that address as her address in my file. I'm not saying she doesn't live at the lake or whatever.
Okay.
And I'll let the court know she called yesterday, spoke with my investigator, wanted to drop charges, but because of the evidence in this case, I think I can prove it regardless. That's why we reached an agreement this morning.
Okay, so what I'm gonna do, Mr. Brousard, based on the nature of your plea agreement, is reduce your bond pending sentencing to $1,000. If you make that bond, there's some very important conditions. First, the very first thing you do when you're released is go to the probation department so they can get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement. The second thing is that you're to have no contact or communication with Lindsay Gaspard. So if she is living there, you're gonna have to find another place to live. You're gonna have to figure that out, okay? If I find out that you're having any contact or communication, or she contacts the DA's office and lets them know that, then you run the risk of me not accepting the plea agreement. All right? Okay, you can go back with the bailiff.
Thank you, Your Honor.
Thank you. Jacoby Frasier,
Was it competency?
let me just go through, y'all don't have an agreement, just, yeah, y'all just need some time?
Yeah.
Okay, I'll make that finding and then reset it.
He's competent, so. Fraser.
Hey, Judge West.
Good morning, you're Jacoby Frasier?
Yes, ma'am.
And Mr. Frasier, it was evaluated for competency to stand trial by Dr. Kaplan in cause number 25 DCCR 0732. I've received that report and will take judicial notice of the court's file. Excuse me. That report is dated November 3rd of 2025. The finding is that Mr. Frasier is competent to stand trial.
Yes, ma'am.
And is there any other evidence with regard to competency?
No, Your Honor.
Not from the state judge.
All right, then at this time, I will make the finding that Mr. Frazier is competent to stand trial. And then, Ms. Holmes, do you need some time to get out and visit with him with that? And
I do know that last time we did have a plea agreement. I believe we had done the paperwork, but then there were some issues where he was needing to be examined.
okay, if y'all want to,
Um,
if y'all want to attempt that, I can hold it. If you want
Okay.
to try to go through it today, then we can take all that into consideration and see if we can get there.
Yes, ma'am.
Okay.
Yeah, I'll try to do that.
Okay, I'll hold it to see if we can get it taken care of. And if you need more time, just let me know.
You gonna talk to me today?
You still have the paperwork? Hold on, hold on. Do you want to talk to him for a minute first and then?
Yeah, let me.
Okay,
check
go ahead and
real quick.
send it, but y'all visit and I'll hold it for a second.
Okay.
Here's what just went down. Michelle Cormier formally waives the indictment, reading and enters guilty pleas in 2 serious cases: manslaughter, a second-degree felony, and possession of a controlled substance, both tied to prior convictions that can enhance punishment. The judge makes it crystal clear she had the right to a jury trial, but she chose to leave punishment to the court, and sentencing gets reset for a pre-sentence investigation report, CY plus letters submitted ahead of the hearing. Then Adrien Banks pleads guilty to harassment of a public servant and receives a 2-year sentence under an agreement, along with a standard firearm ineligibility warning. After that, the most important legal twist appears: competency. One individual is found not competent and ordered for inpatient treatment, while Jacoby Frasier is found competent, and the court pauses to see if a plea can be completed today. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.